Hey everyone, hope you all are fine. I am Harshpreet Kaur from Law Outreach. Today we will discuss about a very basic term which we often use in our day-to-day lives, that is law. Most of us might know that law is a rule of a country which tells its people what to do and what not to do. But when we get deeper into the concept, we get to know that this is a very complex term which is obviously not circumscribed around this definition only. As Arnold, a political thinker, also stated that law can never be defined. But today we will do a quick attempt to understand this term in a more clear way with the help of four major schools of thought which have described this term according to their ways of thinking. Firstly, there is natural law school, which believes law as binding obligations which are already present in nature independent of our will. For example, there are some things which we already know as this is right, this is wrong. This is justifiable, this is non-justifiable. And particularly when we talk about fundamental rights or basic human rights, then this school of thought is invoked. For example, we cannot take anyone's right to eat healthy food or to live a life of peace and dignity. That's all from this school of thought. Moving forward to analytical jurisprudence, there are two main ingredients of this school of thought. Firstly, there should be command given by the supreme authority to its people living in its political territory, and that command should be backed by sanctions. For example, if a person commits murder, then his or her conduct is backed by punishment or sanctions. He can be hanged or sentenced to death. And secondly, if a person does not obey traffic rules, then this conduct is also backed by sanctions. There are some thinkers who have defined this school of thought according to their ways. Firstly, there is the thinker H.A.L. Hart, who defined law as a structure of rules of society. Then comes Kelsen, who defined law as basic norms present in the society which are needed to be followed by everyone out there. Then comes Durkheim, who introduced law as reliance on principles. This school of thought is also known as legal positivism or positive law. Now moving forward to historical jurisprudence. This school of thought believes in connecting law to its ancestral roots and carrying on the spirit of cultural heritage. Some thinkers defined it as F.C. Savane treats law as a spirit of people, their race and culture. Then Henry Maine believes law as movement from status, obviously ancestral status, to contracts or legal documents. This school of thought is called as legal evolutionism. Now moving on to the last school of thought, that is sociological jurisprudence. This school of thought believes that state or the one in power or the authority is just an agency or a medium to give a hard format to the legal values which are already prevalent in the society. And the only purpose of law is to serve the society, and that's all. So this is all from my side. I hope I made it a bit clear to all of you that what is law all about.